right, good morning, everyone. Thank you again for your patience while we worked through some technical difficulties. Thank you for joining us for our, I believe, first ever 2-for-1 webinar where we're going to address two different topics. Today will be the grandfathering deadline and USCIS's age out policy. Before we get started, I just want to run through our normal housekeeping items. First and foremost, this is for educational purposes only and should not be construed as legal advice. If you have any questions on this content, please contact your legal counsel. And all the information in this webinar is deemed to be accurate and up to date as of the recording of this webinar, which is September 30th, 2025. And last but not least, recording or transcription of this is strictly prohibited. Mackenzie, if you can switch over to, I believe, the third slide now. And then, sorry, one more. Thank you to our 2025 webinar sponsor, JTC. We have Jose Rincon here, who will give you a little bit of a background on who JTC is, and we really appreciate their support as they have allowed us to bring this webinar to our members free of charge all year long. Jose?
Awesome. Thank you, Ashley. Good afternoon, everyone. Happy Tuesday. My name is Jose Rincon, and I'm on the business development team here at JTC. JTC is a publicly traded company out of the UK, focused in the US on specialty fund administration. That includes EB5, 1031 exchanges, and DSTs. We work with large regional centers and small regional centers and developers who are just getting into the industry, kind of guiding them and walking them through the process of all the RIA regulations and all the back office operations and needs that they might have to add to their projects to make sure that they're compliant with the RIA. And then with larger regional centers, we provide different types of solutions to kind of help run their back office more efficient and cost effective. So excited to hear from this group of panelists today. And thank you so much for having me. Ashley?
Thank you, Jose. And Mackenzie, if you could switch over, I believe, two more slides now. Yes. So the first half of our webinar will be talking about the grandfathering deadline, which is September 30th of 2026. And I will turn it over to the panelists to introduce themselves and get started with the discussion. George and Lulu?
Sure, I'll start. Lulu Gordon, General Counsel for EB5 Capital. We're a regional center operator, having 8 regional centers covering most of the United States, 48 states. And we're on our 46th project, having been around since 2008. So happy to be here. I'm on the board of IUSA and on the policy committee as chair, and looking forward to the conversation we're going to have today.
Great. Thank you, Lulu. Good afternoon, everyone. My name is George Mackley. I'm the president and founder of the Reserve Component. We are a government affairs lobbying shop in Washington, D.C., and have been representing IIUSA, I'd say, for about 6 or 7 years now. So looking forward, thank you for being here, and also looking forward to our conversation.
Should we just jump in, Ashley? Okay. We're going to talk about grandfathering first. As many of you have now realized, if you didn't do it earlier, we are approaching one of the sunsets in our legislation, and that is the investor protections offered by grandfathering. Those expire on September 30th, 2026, meaning if an investor files before that date, they are protected regardless of whether the statute is reauthorized. Their immigration process will go forward, and visas will be issued if they are approved. If they file after that date, as the statute is currently written, there is no guarantee that their immigration process will continue. That has created a real problem for the industry in that we're concerned that investors will be reluctant to invest after the sunset date of the grandfathering, and that means we'll be at a standstill until we get to September 30th, 2027 to see what happens. We are working hard at IIUSA to prevent the problem, that is, to fix the problem in advance. And George, can you let everybody know what we've been up to in that regard?
Sure. Yes, thank you, Lulu. I appreciate the background. Well, we've known obviously this issue for some time. I think even when we went back to the Reform and Integrity Act when it was passed, we knew this was out there, and it was a conversation that we've had consistently on the Hill. For those of you that maybe are members of our leadership committee, you do know that we have quarterly fly-ins to Washington, D.C. The grandfathering 2026 deadline has always been one of our priorities and discussions. We also, for myself, not only we don't just depend on the meetings that we have quarterly. I'm constantly on the Hill, working with congressional offices and updating them on our policies throughout the days and every year. So I was on the Hill last week, working with offices, and I will be on the Hill tomorrow, talking about our issues. This being one of them. One of the things that we've been doing, and I lean on Lulu a lot for this, is trying to develop language on how we would fix the grandfathering. So with Lulu's help, we've actually developed a language that would amend the current law and trying to figure out how we can then work on that. What we have been taking that language and working with congressional offices to see how they could help us change the law and what opportunities they see for us. So of course we're looking at, even though we're looking at a government shutdown now, but we don't know what the next budget bill will be. So is there an opportunity within this current the discussion of the fiscal year budget to amend this, or do we need to be working from this point forward until the actual deadline to fix it so that there is no gap? Lou, is there anything you want to add on that part?
Yes, yeah. So in those meetings on the Hill that I attend as part of the leadership for IIUSA, and also we have our own lobbyist, EB5 Capital does, Penn Avenue Partners, and we have done the same pounding of the pavement. This has been met with a lot of support. Like, yes, of course it makes sense to get this fixed. We don't know exactly how it happened. It kind of came out when the legislation came out. We were all like, wow, what happened here? Why is there this disconnect? And there were so many drafts and rounds of drafts that, somewhere along the way, a date got changed, but not both dates. So we think we have the support out there. It makes sense. It's important for regional centers to get ahead of this because it affects our pipeline, our ability to commit to funding, and those things go way far in the future. So it is important, and I think we do have a lot of support for this. It's being treated as a technical fix, which is a good thing. And we have, developed language around the context of why it's so important. And we hope we can get it done.
So a lot of the conversations, as I said, we've been going on the Hill. We have seen since the Reform and Integrity Act was enacted, there has been a big swing in investment, especially in rural areas. And so that's what we've been using. We've been using that as a talking point for us to say why the program has been effective, but why we want it to continue to be effective as well. Part of our communication is if there is a grandfathering, if the grandfathering deadline is not extended, that final year of our authorization, we will see a significant drop in investment. Investors are going to maybe hold back and they may say, I don't feel comfortable. So the most critical part of our year, which will be the final year of our authorization, is when we want to show the program firing on all cylinders. And this has a potential of bringing our ability to engage with investors and bring their funds to the U.S. for the projects, create the jobs. We don't want to see that dip. So that's why one of our talking points is saying aligning this grandfathering deadline with our reauthorization at a minimum is what we want to see, because that's what's going to help the program when we actually build past this and going toward reauthorization. We want to show that we've had huge amounts of investment, those dollars here, and we want to show significant job creation to Congress so that they will help us with our permanent authorization of the program.
So we're going to just pivot a little bit and talk about some other IIUSA priorities on the Hill, and then we'll touch on the gold card toward the end of our time period. We are, as George mentioned, we are on the Hill 4 times a year. Usually there's 4 teams, 5 teams doing 6 meetings a day or 8 meetings, sometimes even teams on the Senate side and the House side. And those have been very effective, and we are pushing certain priorities, particularly as we run up to reauthorization. And two, as you can imagine, the two top priorities, there are many, but the two top ones are permanent reauthorization, or at a minimum, long-term reauthorization, so that we're able to really plan and fulfill the promise of the program. And the other is visa relief. At this point, we're talking about visa relief through administrative action. And quite simply, it would be having the State Department reinterpret whether derivatives account toward the visa cap. And that's a conversation we've also been having on the Hill and have gotten a lot of support for it. We think the congressional intent was 10,000 investors. And people can, and IIUSA has prepared some incredible materials about the impact the program has, but also the multiplier impact it would have if derivatives weren't counted. And that can be seen in the most recent economic report that IIUSA commissioned with a third party. So this is what we're bringing to the Hill. The numbers are pretty staggering and positive, and people are really getting it that, yes, 10,000 investors is what was intended, and we need to push on that so that we're not stuck in backlogs as we have been in the past and are starting to see a little bit now.
Yes, I agree with on Lulu's points. I just want to expand on some of those. Going back, so 1990, when the program, the visa was actually created, we have correspondence that actually talks about 10,000 investors, and so that was the goal. So we continue to use that as our foundation, as saying when we're looking at the visas that are allocated today, they're not allocated to 10,000 investors. They are allocated to the investor and then also any of their family members, so the derivatives. That only means that only about a third of those visas that are allocated go to an investor. We have significant amount of opportunity if they were to go to congressional intent and look at the 10,000 investors. We have talked for a number of years on the Hill to offices about trying to find ways to get visa relief or additional visas, and it has been a challenge. A number of offices have said this isn't somewhere where we're willing to go. However, when we look at the intent and saying, well, at least that we know that there are 10,000 visas for investors, how can we make sure that we get that count corrected? One way to do that, and what we're looking for is, and then once again leaning on Lulu, is developing language, and we have, saying that if you're looking at congressional intent, it really goes to the State Department, how they're allocating the visas, and that actually is interpretation that's done through the Foreign Affairs Manual. So let's work with Congress, not for legislative text, but for legislative interest in how the State Department is allocating those visas. We continue to see, and it has a lot to do with those meetings that we are consistently having on the Hill, what the overall feeling for EB5 has really been very supportive. And I'd say 2-3 years ago when we were on the Hill to where we are now, totally a very different dynamic for us. So let's take advantage of that and move forward. If we can actually use Congress's support of essentially derivative relief, then actually have them lean in on the executive or the Department of State on how they're allocating those visas.
So we do have many other policy and legislative priorities that we're bringing to the Hill, but we wanted just to cover those two top ones in this period. We're going to talk about the gold card. Before I throw it over to George, I wanted to just talk about the day in February where this gold card was announced. The leadership group had been on the Hill all day, in offices all day, telling them how fabulous we are and how we should be reauthorized. And we all got back to the hotel, and we were being told we were a silly little program that was going to go away. And after getting over the initial shock, for me, it felt a lot like having the RIA pass and USCIS telling us we were all debarred. It was a deja vu. And we can see that the administration has walked itself back from that quite considerably. And IIUSA smartly, and the industry has been uh, focusing on the opportunity the gold card program may offer us, because it's, you know, immigration by investment has been legitimized for Republicans and other folks who may have hesitated. So, George, why don't you tell people what we think we know
Mm-hmm.
about, based on the EO that came out, and then I'll hop in at the end.
I'll say too. So you go back to February 25th when the president and Secretary Lutnick were in the Oval Office, and they talked about the gold card. Their number one essentially target for to replace would have been was EB-5. I think since then you have seen a number of folks. We've actually had phone calls, and some of our members have had phone calls from members of Congress saying, "Hey, I saw this. What can we do to help?" This is exactly what we've been trying, almost like what we've been training for. Essentially, this is that part where we've been doing the hard work up into February 25th of actually getting out there, publicizing the great work of EB-5, where you have now members of Congress that are really engaged in saying, no, I want to make sure that this program is around for the long term and that it continues to help my district or my state. Just like you had members of Congress that were proactively reaching out to us, we also started to see some, I'll say comments in the press from individuals and organizations talking about EB-5 too. A lot of that had to do with how the gold card and what the president is trying to do with his immigration by investment program, which is really bring down the deficit. And then you have a different group, which that's his intent. And then you have congressional intent with the EB-5 program, which is job creation. And so you have these two things, and we've always said that they can run in parallel. And I think because what you've had in Congress being supportive of EB-5 and making sure that it's around for the long term, and then you have comments coming out, even op-eds coming out. I think there was even Stephen Moore had one. So obviously, economist early on came out saying gold card's great, but EB-5 is great too. Those are the types of comments I think that really helped kind of change the conversation of the gold card and where they were going. And then what you have now, just more recently, with this more recent announcement of we're actually signing of an executive order to establish the gold card, where you do have them looking at saying we're going to be looking at EB-1 and EB-2. Now, one thing, once that gold card EO is signed, I mean, Lulu was right on it and came and sent us emails saying that there is a reference of EB-5 in this executive order. So, Lulu, if you want to talk about that.
Yeah, I think, again, trying to have a positive lens on this. Clearly, the president is looking to use existing visa categories, cannot create a new one by executive order. And so how can that happen, particularly with all of them, but EB-1 and EB-2 are already backlogged. So what happens to the investors that have been waiting years and years, or not investors, I'm sorry, but immigrants waiting years and years to come in? And those programs also count derivatives toward the visa cap. So I think this is a great opportunity, and this is the thought I think I want to leave people with. If the president wanted to expand the use of the gold card in those categories, not counting derivatives would be a very smart move. And if that happens, I think it's an inroad for us to further push on not counting derivatives in EB-5. And we already have other reasons, as George mentioned, the congressional intent and history. But the more we can legitimize the idea in other categories, I think the stronger argument we will have. And it will change the landscape for sure of the EB-5 program if we're not counting those derivatives toward the visa cap.
I totally agree, and I think that's what we're working strongly with our other partners, our other stakeholders, to make sure that we're protecting EB-5. There needs to be much more clarity around this executive order. I've had a number of meetings already on Capitol Hill speaking about the gold card. There are a number of questions still there. So as this evolves, we'll be sure to make sure that we're representing IIUSA, the members on the Hill, and supporting and maintaining and strengthening EB5.
Great. Okay, Ashley, are there any questions for us?
I am checking. Let's see here. Um, let's see. Is there any chance that sponsors of the RIA would provide language to support the visa allocation issue? I don't know that DOS, with its current negative stance on immigration generally, would be amenable to expanding how visas are used.
That's a good question. And I think there's also a lot of pushback by members of Congress on allocation. Ideally, we would handle derivatives through a legislative change because then it's not open to, going which way or that way, depending on who's in office. But for now, we're focused on this administrative change, and we're going to have to marshal, all of our friends to try to get this done in Congress and elsewhere. So it's a good question, and we're working on it. That's all I
Yeah.
can say. We're very aware of the problem, and we're working on it.
So the sponsors of the RI, we have three left, essentially. If you're looking at the sponsors, those that introduced the legislation. In the Senate, it was Senator Grassley and Senator Leahy. Senator Leahy has retired. Senator Grassley, chair of the Judiciary Committee, is still in office. And then you have Mr. Greg Stanton from Arizona, and then Brian Fitzpatrick from Pennsylvania, both still in Congress. They were the bipartisan co-sponsors of the Reform and Integrity Act in the House. There definitely is interest there, and they do support what we are trying to do. But I think there also is a reality of there will be challenges with legislative action on derivatives or the visa count. So that's why we are pursuing hopefully an administrative fix to this.
And then we have one more question. Can the president use an executive order to not include derivatives?
I think we believe he could.
I believe he could, but we also don't think it needs to go to the level of the president. This could be done at the Secretary of State level, because it is an interpretation of the Foreign Affairs Manual, how the allocation is being conducted, which is where we are focusing.
Okay, well, those were the two questions. So if you all have any closing remarks, you got a couple minutes here still.
Thanks. Thank you for inviting me.
No.
And JTC, thank you for sponsoring it. And always wonderful to talk to George. So thanks, everyone.
Nope. Thank you very much. I appreciate it, Lulu. Thanks for all your guidance, especially as we go through whether it's the grandfathering, the derivatives, or it's even the reauthorization. Your leadership is very important to us. And I also thank the JTC for their sponsorship as well. Thank you, IIUSA.
Thank you both. And with that, we will switch over to the second half of our 2-for-1 webinar. We can get, looks like Michelle and Jess, get everyone's audio and visual working. There we go. All right. The next section of this webinar will be on the new age out policy that USCIS announced last month. And with that, I will turn it over to Jessica and Michelle to introduce themselves and get going with their content.
Great. Thanks, Ashley, and thanks to Lulu and George for that update and for all your efforts. I'm Michelle Franchette. I'm an attorney and a partner with SGG Immigration in Los Angeles. And we represent a number of regional centers as well as individual investors, and also do employment-based immigration. And with me is Jessica Denisi. Jessica, do you want to introduce yourself?
Sure. Thanks, Michelle. I'm Jessica Denisi. I am also an attorney and partner at Clasco Immigration Law Partners. I'm based in New York. Clasco is a boutique immigration law firm. And we have a practice group that I head up that is focused on EB-5 project and development work.
And ladies, just a quick reminder to prompt to go to the next slide since I am not the one controlling it from my technical
Okay.
issues.
Okay, great. Let's go ahead and jump to the first slide. So today, Jessica and I are going to cover the change in CISPA, or Child Status Protection Act policy of USCIS. And before we get into the details of the change, we want to just lay some groundwork here of what CISPA is. So we're going to cover that and how you calculate age under CISPA, and then get into the details of what changed and the difference between the two charts in the visa bulletin, the final action date chart, and the dates for filing chart, and what the consequences of USCIS using one or another is. Next slide, please. So what is CISPA? So this is the statutory language that you can look at later, but basically it requires that you calculate the age when a visa becomes available and deduct the time that the relevant petition was pending with the USCIS from the child's biological age when that visa became available. And then you lock in their age when that visa became available. And then there's a condition attached to it that they have to take steps to go ahead and pursue their application for permanent residence within 12 months of that visa becoming available. So this term, visa becoming available, becomes very important. Next slide, please. And so that's a lot of what we're going to talk about is when a visa becomes available. So first, we're going to talk about what USCIS policy is and their interpretation of when it becomes available. So currently, if you look at their website, this is what it says, that a visa becomes available on the later of either when the 526 petition was approved or when the visa bulletin indicates that the final action date is after the filing date of the 526 petition. So it's the later of those two things, either whichever one occurs later in time. And so according to USCIS policy, if you file your 526 before the final action date shows that your filing date is current, visas are not quote unquote available yet. So that's the USCIS position on it. Next slide, please. And so I'm going to turn it over to Jessica here.
Thanks, Michelle. So on August 8th, USCIS announced a policy change that just affects how the child's age is calculated under CISPA. So now the agency will only use the cutoff date provided on the final action dates chart, so that's chart A of the visa bulletin, to determine whether a child has aged out and therefore lost eligibility for a green card through their parents' approved immigrant visa petition. So this change in their policy, it aligns the CISPA age calculation method that would be used for applicants inside and outside the United States. There used to be a difference based on whether you were applying for adjustment of status in the US or for a visa, an immigrant visa abroad. So USCIS will start applying the new policy to adjustment of status applications, forms I-485, submitted on or after August 15th. So applications that were filed before the 15th will still be processed under the prior guidance, the February 2023 guidance. Next slide. So this policy shift, this change that they announced last month, it means that Based on their interpretation and guidance, a child could still age out after the AOS is filed if they're filing under the dates of filing chart. Next slide, please. So this is now, just to summarize, this is the big takeaway. USCIS is taking the policy position, that for purposes of the CISPA calculation only, USCIS will use the final action date for purposes of locking in or freezing the child's age, again, for CISPA. So this means that USCIS is taking the position that a child can still age out if an AOS is filed based on the dates of filing chart. Michelle, I'll let you take it now.
Okay, so let's go to the next slide. And this is just a little tool that you might find handy for calculating CISPA. A few years ago, we had a really smart assistant who knew Excel and made a calculator for us where we could plug in these dates and it would calculate how many days the petition was pending and how old the kid would be. But but this is just a visual of the process of calculating an age under CISPA. So you start with the child's birth date and the date that you file the petition. And then, so that gives you the biological age and the date you file, your priority date. And then you look at the date the petition was approved, and then figure out how many days it was pending. And then that's how much you could deduct from their age. But you can't do that yet until a visa becomes available. And so when the visa becomes available, that's when you deduct the number of days the petition was pending from their biological age. And so, and then you come up with the age. And so that is how the system worked before February of 2023, and then now again after for petitions filed after August, or applications filed after August 15th, or as of August 15th. So that's a little tool for you. Let's go to the next slide. So again, if you filed your adjustment application before August 15th, 2025, they're going to use the policy that was in place that was announced in February 2023, that lets you consider visas available based on the dates for filing chart. So you do get an earlier lock-in date, which is going to save some kids. So then let's go to the next slide. So this is before, this is just a little history. Before USCIS changed its policy in February of 2023 to use the dates for filing chart to recognize CISPA age lock-in, AILA was advocating for them to adopt that policy, and then they did. And then this was a lawsuit that was filed to try to get the court to require the State Department to recognize the dates for filing chart as the visa availability date for purposes of CISPA. But this case was not decided in the plaintiff's favor, and the court said that because no visa could actually be legally issued on the date that they were claiming was the date of availability under the dates for filing chart, it would have been illegal to issue the visa on that date. So they would not recognize it for CISPA as being, quote, available. So that's just for background. And then the next slide is a summary of, the history of where DOS and USCIS have stood on this over time. And so you can see that originally both used the final action date as the date for locking in and recognizing visas available. Up until February of 2023, when USCIS departed and started using dates for filing. And then it switched back. So there's that. That's just for your information and reference. So then just to bring it all home on the next slide, we are illustrating here the impact of using on the left the final action date chart, and on the right the dates for filing chart to calculate the age under CISPA. And so here you can see the difference in impact, where under dates for filing, they're under 21 at the end of the day for CISPA, whereas under final action date, they're not. And so unfortunately, there are going to be some kids that fall into the age out situation. And then next slide, we're going to turn it back over to Jess to talk about some of the controversies.
Thanks, Michelle. So we mentioned several times over the course of the presentation that these updates and the interpretations discussed are, USCIS's current policy position. But there are other, or I guess, alternate interpretations of how CISPA interacts with the two visa charts, when using concurrent filing. So the first thing is that INA 245A, which is the statutory provision that allows for, that provides for the filing of an adjustment of status, it provides that the AOS, the adjustment of status, may be filed when a visa is immediately available. So that would seem to mean that, if you've filed and thereafter, even if the bulletin retrogresses, the visas aren't current anymore, as USCIS can only allow for filings that are in keeping with the requirements of the INA, right? Theoretically, they can't violate the statute. A visa should be deemed available, therefore, regardless of the chart used or whether there is a subsequent retrogression after the concurrent filing. Because any other approach, any other interpretation would contradict that statutory provision that has, kind of baked into it, that a visa is immediately available. This is not necessarily to suggest that an investor should, file relying on this interpretation of the law, but I think it is a valid reading of the statute, and certainly an argument that an attorney or an investor could advocate for if need be. And this second controversy here, and Michelle, I'll probably ask you to jump in here, is slightly different. It touches on the issue of whether the petition needs to be approved before the visa actually is considered to be made available. Michelle, can you?
Sure. So earlier we talked about the USCIS website explanation of their interpretation of the requirements for CISPA, and it said that it had to be, visas were available on the later of two events. One was the approval of the 526 petition, and the other was the final action date being indicating current, that your priority date was current. So their interpretation is, oh, it has to be the later of one of those two things. And so by implication, that requires the approval of the 526 petition. But when you think about it, you could file a concurrent 526E petition and an I-485, and assuming the final action date chart indicated, no backlog, that it had a C for current, right? Um, you filed both your 526 and your I-45. Theoretically, USCIS could adjudicate and approve the petition and the application and issue an immigrant visa and immigrant status that day. So, the argument is, well, yeah, it could be adjudicated right then and there, so it's immediately available. And so the argument would be, like, let's say you file and then later it retrogresses, and then later your 526 petition is approved and your 45 is still pending. Um, the argument would be, well, we locked in when we filed, right? Because the final action date chart was current. And so so that's the argument. But and the website doesn't really get this granular to talk about this particular scenario, and it could be that their content, um, where it says, oh, it must be either this or that, the later of this or that, that could very well be old content from pre-2023, where before they even started allowing these concurrent filings based on date for filing. So that's just something to think about. And with that, I think we're going to open it up for questions if there are any. I don't see any in the chat, so
If you go to the bottom of your screen, Michelle, you'll see a Q&A box. It's
okay.
separate from the chat. Do you
Oh,
see
oh,
that?
got you. Okay, okay. Um, So the first question says, but the age will only lock out if when you apply the I-140, the priority date was available to also file a 45, right? So I'm trying to think what they mean here. So
So I
so go ahead.
no, well, I'm sort of guessing. So USCIS is taking the position that if you are, or that they don't um, have examples with concurrent filing in the policy manual. But the guidance that they have online is suggesting that if you're filing under the dates of filing chart, if the number is current there, or rather, if you're the better way to say it is if you're filing under the dates of filing chart, but the final action date isn't available current yet, it's you're not necessarily locking anything in there. USCIS is taking the position that a child could continue to age even after that point. I'm not entirely sure I'm understanding the question, so I'm not sure if I'm answering the question, but I, I I think that's the question.
Um, there's another question saying, what protection would an investor have for a backlogged country who is current but is processing through an embassy, such as Abu Dhabi, I guess, who is scheduling an interview for DQ dates in 2023? While they are eligible, they would essentially still be waiting an additional 2 years for processing. Um, so when you're consular processing, it's actually quite clear, because Department of State has never changed their policy, and so um, they will look at the number of days that your petition, your 526 petition, was pending with USCIS. And they will deduct that from the child's biological age when visas become available. So if the petitioner's priority date is still backlogged, then we don't know if deducting that number of days will be enough to protect the child, to keep them included as a qualifying dependent. So you have to wait until the visas become available, and then you can run that calculation and see if deducting the number of days the 526 was pending will keep them under 21. And then, of course, after the visas become available, you have to take steps to pursue the application within 12 months of availability to make sure that locks in. So I hope that answers the question. And we have time for more questions if anybody else wants to submit one. If not, I guess that's it. It's a complicated area, so it's probably hard for people to articulate, some
Yeah.
questions. Or if they understand it, it is what it is, So it's an unfortunate reversal of policy by USCIS. I know a lot of us were hoping that instead of reversing it, that Department of State would go ahead and adopt it because it would help so many kids be included as qualifying dependents. And so sadly now I worry about the people who file adjustments based on dates for filing, thinking that their children will be included because they were able to file, but then they may age out while the whole thing is pending. So because, it may take too long for the final action date chart to move forward. So I'm hoping that people go into it now with their eyes wide open and well informed, so that they're not at least caught unawares of the impact of this distinction in visa availability for purposes of filing a 485 versus locking in CISPA. That's what it boils down to, is USCIS is saying visas are available for 485s, filing 485s based on the dates for filing chart, if we allow it that month. But for purposes of CISPA, visas are available only according to the final action date chart. So it is a rather contradictory stance to take. And so, yeah, that's about all I have to say. Jess, do you have any final thoughts on it?
No, I think that's it.
Oh, here's a question. Could the principal investor or spouse of an I-130, could the principal investor or spouse file an I-130 for their underage children as LPRs? So I don't know. I'm trying to imagine why you would do that. I guess because if the principal investor and spouse are LPRs that are capable of filing I-130s, I don't know why their
Right.
children would not be LPRs also, unless maybe their child was born um, outside the US and they never brought them in within the first 2 years of life. And in that case, they could file an I-130 for them as would be, what would that F2 be, I think, family-based second preference. So, okay. Well, thank you everybody for attending, and thank you, Ashley and IIUSA for putting this seminar on and keeping us up to date.
Thank you, Michelle and Jess, and again to Lulu and George. And thank you all for attending. This recording will be available on our education library. Just be on the lookout for an email that will include a coupon code so you can access it for free as registrants of the live webinar. And again, thank you everyone for attending and be on the lookout for our Q4 webinar. And thank you again to JTC for sponsoring our 2025 webinar series. I hope everyone has a great day.